Good morning, everyone. Welcome. My name is Emma Brooksbank. I'm a partner at Freets and I head up our business immigration team. You've joined us today for the third of a series of 4 webinars, which overall are dealing with the transfer of employees into the UK and from the UK overseas, and the transfer and establishment of businesses in the UK and of UK businesses overseas. In today's session, we're going to be focusing on businesses which are looking to transfer and establish themselves into the UK. Now, you'll see that I've been joined by a broad team of experts today, and one of the real advantages of working in a large national firm like Freeds is that we can bring you a host of different perspectives on this subject. So today I'm joined by my colleagues Ellie Davis, an associate in our corporate team, Tom Draper, partner in our employment team, Roger Goff, consultant in our commercial team, and Callum Kamara and Adrian Hackett, trainee and partner respectively from our taxation teams. And together we'll talk you through all of the essential requirements and compliance measures and important things that you will need to be thinking about on your client's behalf when they are considering establishing a business in the UK. We will have time for some questions at the end, and as Tom mentioned, please feel free to pop those into the Q&A as we run through the presentation today. If we don't have time to answer all of the questions, we will come back to you personally to provide you with an answer. The slides and presentation from today's session will be shared with all who have registered for the session. And at the very end of the slides today, you'll find a QR code which will enable you to register for the final session in this series and also to receive the previous presentations. So I hope you enjoy today's session. I'll be returning later on to discuss the immigration elements which you may need to be considering when setting up a business in the UK. But for now, I'm going to hand over to Ellie from our corporate team, who will be talking us through corporate considerations on the establishment of an overseas business. Over to you, Ellie.
Thanks, Emma, and good morning, everyone. So I'm just going to be running through the choices that you have in terms of which corporate vehicle to use when setting up a trading operation in the UK. So you've got 3 main options that are set out on the slide, as you'll be able to see hopefully now. So the first option is a private limited company, which most people will know what those are. So this would involve incorporating a UK subsidiary of your overseas company. You can do this using model articles of association or bespoke articles. So the articles of association are the constitution of the company, essentially its rule book. So for that reason, we usually recommend adopting bespoke articles on incorporation. You can incorporate the company with model articles and then adopt bespoke articles later on. So you don't have to make that decision straight away. Either way, whichever option you go with, the articles are registered at Companies House and are available for public viewing. Decision making wise, so with a limited company, decisions are made at both shareholder and board level. So some decisions may require shareholder approval and some decisions can just be made by the board of directors. This will depend completely on what decision it is that's been made and what the articles say about that kind of decision, and also what provisions are in the Companies Act 2006, which is the main piece of legislation that governs limited companies and LLPs and other corporate vehicles. On incorporation of a limited company, initial funding will usually be a mixture of subscribing for shares or loans coming in from a parent company in order to fund the business. So the next option you have is a limited liability partnership, or an LLP. So as the name suggests, an LLP has partners rather than shareholders, as with a limited company. LLPs are governed by the LLP agreement that's in place for that particular LLP, which is negotiated by the partners themselves. This isn't a public document, so this doesn't need to be registered at Companies House, which can give a greater degree of privacy, therefore, than a limited company. There's also a greater degree of flexibility with LLPs when it comes to the withdrawal and admittance of members, because this is done in accordance with the LLP agreement. Whereas with a limited company, shareholders would have to transfer their shares to another individual or have those shares bought back by the company in order for that shareholder to be essentially removed. Decision making wise for an LLP, so decisions are made by the members. They sort of adopt a dual responsibility for the ownership and the management of the business, which is kind of similar to an owner managed limited company, which is quite common where the shareholders and the directors are the same people, but that isn't always the case. So with a limited company, you have the option to have shareholders who aren't directors and directors who aren't shareholders, so two separate groups of people. Whereas with an LLP, the members are responsible for the decision making and the management. There are also some differences in the tax treatment between limited companies and limited partnerships, but that's going to be covered by our tax team later on in the webinar. So I won't go into detail on that now. But they are both essentially legal entities and they both limit the liability of their shareholders or members. So in a situation where you would be using one of these corporate vehicles to set up a trading operation in the UK, this would be the entity that would employ individuals, enter into contracts and potentially hold property or assets as relevant. Just in terms of profit distribution, so the profits of a limited company can be distributed to shareholders or retained for working capital or reinvestment, whereas the profits of an LLP have to be distributed to the members in accordance with the LLP agreement. And then the last option that's on the slide, so permanent establishment. If it wasn't desirable or possible to set up a UK entity to trade through, the other method would be setting up a permanent establishment in the UK, which, depending on the nature of your business, could involve opening a branch office or appointing an agent who would exercise their authority to do business on your company's behalf in the UK. But more details on permanent establishments will be covered by our tax team later on. Next slide, please, Tom. So there's just a few administrative considerations to take into account when you are deciding whether to incorporate a UK subsidiary, whether that be by way of a limited company or an LLP. So statutory registers, every corporate lawyer's nightmare, we all hate them. But at the moment, unfortunately, it is a legal requirement for these to be maintained. So at the moment, you have to have registers of members, debenture holders, directors and secretaries, chargers and persons with significant control. And that requirement applies to both limited companies and LLPs, so there's no way out of it. There is some upcoming changes to the legislation which will remove the requirement to maintain separate registers for directors and secretaries and for persons with significant control. So it is a positive change, but we would still recommend maintaining these registers just for completeness. Companies House filings, so various things have to be filed at Companies House for both limited companies and LLPs, but in particular, confirmation statements have to be filed annually for both limited companies and LLPs. This is where you would report any changes in your shareholding or members. And also accounts have to be filed annually for both limited companies and LLPs. So this is really important because there are financial penalties that can come into effect if you don't file those documents. And also failure to file can lead to either the limited company or the LLP being struck off the register. So we would recommend having a specific person that is responsible for Companies House filings, just so nothing falls under the radar. And then the final thing that I just wanted to touch on from a corporate perspective. So the Economic Crime and Corporate Transparency Act 2023, also lovingly known as ECTA, because that's just a very long name to be saying all the time. So this is a piece of legislation that's coming in kind of on a piecemeal basis. But one of the aims of this piece of legislation is to place further restrictions on corporate directors. And so to this end, the legislation has set out plans to implement a ban on overseas companies acting as corporate directors. So UK companies will still be able to act as corporate directors, but those companies have to have an all natural person board. So you can have one company with a corporate director, but then the board of directors of that company has to be individuals. and you won't be able to have overseas companies acting as corporate directors. There's also more stringent measures regarding ID verification that are coming into force in autumn this year. So a lot of these measures are still subject to change, and they do change on a weekly basis at the moment. But this, whatever happens, the changes will create a higher administrative burden for anyone who is a director of a UK company. So that's just worth bearing in mind as well. And that's it from me. Thank you.
Thanks, Ellie. Okay, my name's Tom Draper. I'm a partner in the employment team at Freeth, and I'm here to talk about the employment considerations of setting up in the UK. So once you've decided what kind of corporate vehicle you want to use, there are some initial employment considerations to look at, the first of which is recruiting staff. So in the UK, we have three types of workers. You've got employees, and most people will be familiar with those. High level of control, a requirement to provide them with work to do, and a requirement on the employees to do that kind of work. And then on the other end of the spectrum, you've got self-employed contractors who've got much more flexibility over how and when they work. And in the middle, you have workers. And the importance of deciding which type of staff you're going to have in your business is the fact that these different three categories of staff all have different entitlements. So employees will have an entitlement, for example, to a redundancy payment after 2 years, or the entitlement to claim unfair dismissal. Whereas self-employed contractors aren't able to bring employment tribunal claims unless they're claiming discrimination. So each of the types of staff will have benefits and disadvantages. So self-employed contractors broadly, much more flexibility, but then much less in terms of employment entitlements as well. So once you've decided which type of staff you're going to use in your UK entity, you've got to then look at registering with HMRC and setting up payroll for these employees, or workers or self-employed contractors, depending on which you decide to use. There are then pension scheme obligations to take into account, and you've got auto enrolment to deal with. From the first day of setting up, if you've got staff, then they need to be enrolled into a pension scheme if they are eligible job holders. So for someone to be an eligible job holder, they need to meet three conditions. Firstly, working in Great Britain under a contract. Secondly, being between the ages of 22 and state pension age. And thirdly, meeting limited criteria for earnings. And as long as these three relatively easy things to meet are met, then as an employer in the UK, you'll need to auto-enroll employees onto a pension scheme unless they opt out. The easiest way to do this is using the government's National Employment Savings Trust, or NEST, pension scheme. If you do this, it's easy for employers to set up and manage, and it automatically generates the required level of contributions for your employees, which is 3% for employer contributions and 5% for employee contributions. So a total of 8% altogether. A word on TUPE then. If you are purchasing a business in the UK, or you're taking over an existing contract, if there is an economic entity which is transferring as part of this process, which retains its identity, or in relation to the contract, you are contracting the work out, you are bringing it in-house, or you're changing the legal entity that is servicing that contract. This could be a service provision change under 2P. This has three main consequences. Firstly, you've got the automatic transfer principle. When employees in the UK transfer under 2P, effectively the buyer or the new contract provider steps into the shoes of the old employer, and the employees transfer to the new employer with all their continuity of service and their terms and conditions of employment intact. The second point is that they're protected from dismissal in relation to the transfer. And thirdly, there is an obligation on both the buyer and the seller to inform the employees about the transfer and consult with them over any proposed changes. So it's worth thinking about whether or not TUPE is going to apply at the point that you set up your business in the UK. And the final thing on the slide is about liability insurance. So this will depend specifically on what kind of sector the business is operating in, what kind of insurance that the company will need to have in place to protect themselves against any liability that might arise. So let's have a look at the next slide, please, Tom. So in the UK, there's a requirement for a written statement of employment particulars, also known as an employment contract or a Section 1 statement. And in a Section 1 statement, there's a requirement to give both employees and workers written information about a whole series of things that they will need to know about if they're working for you in the UK. For example, they'll need in the written statement of employment particulars, will need to state the scale and rate of play, the place of work, the employee or worker's holiday and sickness entitlements, their pension terms and conditions, the length of any notice period that's required to end the contract, and also any training and benefits that the employee or worker is entitled to as part of their work for you. And if this isn't provided, then an employment tribunal claim can be brought on the back of another claim, and you can claim either 2 or 4 weeks' pay if a compliant Section 1 statement isn't provided. There's also a requirement to provide HR policies and procedures. The mandatory ones are the ones in the top bullet point there, disciplinary and grievance procedures, but there are a whole host of other core policies that we would recommend having in place. Codes of conduct, policies about holiday, sickness, and other types of family leave, bullying and harassment policy. There's a new legal obligation to do everything reasonable to prevent sexual harassment. So we would recommend having a standalone sexual harassment policy in place. And then other core policies include flexible working, whistleblowing, data protection, IT and social media policies. And you can get a whole raft of these put together for your employees. And it's a good idea to do this up front at the start so that you know how to manage issues as they arise. And the final point to think about on this slide is health and safety obligations. So there's a requirement to have a health and safety policy and also do regular risk assessments depending on the type of work that your workers and employees are going to be doing. So let's have a look at the next slide, please. So the final points to make here are around some of the statutory rights that employees have when working for you. The top bullet point there is the national minimum wage. So this is currently £12.21 per hour for employees 21 or over. Then there are other statutory rights that employees have from their first day of working for you, such as the working time regulations. So a requirement not to be made to work more than 48 hours per week over a 17-week reference period, rights to maternity, paternity, shared parental leave, and then there are statutory rights to notice as well. So an employee has the right to 1 week's notice for every full year of service, up to a maximum of 12. You can enhance these rights using the contract of employment or Section 1 statement that I've already mentioned. But there will be, even without that, a number of basic rights that employees have by virtue of statute. And the key ones to consider here are unfair dismissal. At the moment, an employee needs to have 2 years continuous service to bring a claim for unfair dismissal, but the government is proposing to change that, and there is a law that's being consulted on at the moment that's likely to come into force in October next year that removes this need for an employee to have 2 years continuous service to bring that type of claim. Other claims that employees might be able to bring relate to discrimination and harassment, and these are what employment lawyers call day one rights. So this is a right that an employee has not to be discriminated against on the grounds of 9 protected characteristics, including age, race, sex, sexual orientation, and disability. And so you need to be aware of these to make sure that you are preventing, spotting, and dealing with any discrimination that happens within your business. So they're the key employment law considerations of setting up in the UK. So now I'm going to pass over to the next slide to see what Roger has to say about commercial considerations.
Hey, thanks, Tom. On commercial considerations, there's basically 3 areas that I'd like to highlight. The products to be distributed, the routes to market for those products, and then the protection of rights. So briefly looking at the first of those, you need to be able to demonstrate that the products you make or import comply with relevant regulations and meet safety requirements before you put them onto the market. You also need to make sure that consumers are provided with adequate information so they can use products safely and ensure that the product can be traced back to you should there be a problem. Now, helpfully, the British Standards Institute has a comprehensive standards library for UK businesses, so that can be consulted because obviously this is very product specific. It should also be noted now that certain regulated products are required to be marked with the UKCA mark, the UK Conformity Assessment or Assessed mark, rather than the European CE mark. Now, there are other regulatory requirements which could include labelling. The products may need to be labelled properly. This is particularly important in relation to food and cosmetics and pharmaceuticals. And also environmental regulations, which may impose obligations for recycling, emissions control, and sustainability. And depending on which sector you're in, there may be sector-specific regulations to comply with, particularly in the financial services area. You'd need to comply with the Financial Conduct Authority and the Prudential Regulation Authority. Now, looking at the routes to market, obviously you've got the goods, you know what you're going to do. How are you going to get them out to customers? And this is not going to be too dissimilar to routes to market in other jurisdictions, but there are 1 or 2 key points to flag. So first of all, selling directly, direct sales from following an inquiry or on your own website. But those sales should be on a set of terms and conditions which you're happy with. Now, you may have a set of terms and conditions that you've used in other jurisdictions, but it's probably not a good idea to just simply use the same set of terms and conditions, because within the UK there will be different Sale of Goods Act provisions which need to be modified and included in those terms and conditions. Also, in relation to consumer terms and conditions, they will have a very different look and feel, because consumers need to have sets of terms and conditions which are fair and easy to understand. You may also have come across in other jurisdictions the importance of making sure that your terms and conditions are actually incorporated into the contract. And that would be a battle of the forms, as you may have heard it referred to, where each party is seeking to impose their terms and conditions into the contract. And here it would be the business that can say that they had their conditions referred to last in that particular battle that wins over, and it's their conditions that would then apply. So other routes to market would include online marketplaces such as Amazon or eBay, or via retail distributors. So this could be the larger supermarkets. Here, though, you will find it more difficult to impose your own sets of terms and conditions. You may well be looking to sign up to the supermarket's terms and conditions. And also, they will have supplier codes and policies, and some of those are very detailed and quite onerous, so they always need to be looked at as well. On the wholesale side, you may well want to appoint distributors, a distributor that would then buy from you and then sell on those products to customers. They would buy them, they would make their profit through the margin, the difference between the price they pay to you and the price that they then sell on. They then take the risk on the sale, which is a different model to appointing an agent or a sales agent, which I'll come on to shortly. Distributors can be guaranteed exclusive, sole or non-exclusive rights, and that can be over a territory or a customer group. But then care will need to be taken to ensure that those agreements comply with UK competition law, and if there's any European element, also competition concerns at an EU level. The next potential route to market would be through a sales agent or a representative. They would then represent you, seek to find purchasers for the products, and likely receive a commission for their efforts. So their return comes through the payment of this commission based on sales, rather than buying the products and selling them on. Again, they can be exclusive, sole, or non-exclusive. But the key thing to remember here, though, is that despite the fact that we have left the European Union, we still have the Commercial Agents Council Directive Regulations 1993, which do impose certain provisions which need to be included in agency agreements. And particularly important is where those agency agreements are terminated, an agent is going to be entitled to compensation or indemnity on termination of that agency agreement. Now, this is agency agreements for the sale of products. Services contracts don't fall within those regulations. Other routes, licensing or franchising. If you've got a brand and you want to get that brand out there quickly, you may want to go through a franchising route, or establish a joint venture and share risk with a third party. So finally, if any of the products are sold in the UK are subject to license rights, so if you have a license from a third party elsewhere, it's also just worth checking that the license that you have does allow you to do what you want to do in the UK. And that does lead me on to the sort of final area we wanted to highlight, which is protection of rights. So before sharing any confidential information or business secrets with any third party that you're dealing with or seeking to have an arrangement with, you should be entering into a non-disclosure agreement or a confidentiality agreement, so that looks well, both parties then realise that what they're dealing with is confidential and shouldn't be shared. You should also ensure that your trademarks are adequately protected and don't infringe any existing marks, and there are searches that you can undertake to deal with that. Care should also be taken if you're dealing with or using music or images or software, that you're not infringing anyone's copyright. And also, if your product has a unique design, there's potential for registering that design and protecting it that way. So that's an overall, a broad interpretation of the or a broad summary of the three areas which I think you should be considering when moving into the UK from a commercial contracting point of view. So now I'll just hand over to Emma, I think, who's going to tell us a little bit about the immigration considerations.
Brilliant. Thank you, Roger. It's always good doing these sessions because I learned so much from my colleagues during them. So I'm just going to spend a short time talking through some of the key immigration routes that you may wish to consider if you're thinking about moving to the UK to establish a business, working under the assumption that you've already been to the UK, perhaps as a business visitor, and you've scoped out your business idea, you've signed leases and contracts as might be required, and you're ready to go. Also working on the assumption, of course, that you're an overseas national and that visa clearance will be needed. So the first route to consider is the one in the top left there, innovator, founder, and this is really a route for entrepreneurs. So this is for a person or persons who have a fantastic new business idea and they're convinced that the UK market is the place to launch that business. Now, importantly, you have to be able to establish and satisfy the Home Office that you're bringing something new to the UK market. It can't be a tried and tested model that's been seen before. And the reason for this is that in order to secure an endorsement and therefore a visa, you need to be meeting certain requirements, and the key to those requirements is that you are able to demonstrate that your business concept is innovative, so doing something new, finding a niche in the market, that it's viable. So while there isn't a strict investment threshold, you do need to be able to show that you've done the maths and that you can support the business and that it is a realistic concept, and also that it's scalable. So the UK is looking for businesses that have the potential for growth and the potential in most cases to eventually employ resident workers. Now, unlike the other three categories that I will be talking about, this route is an endorsement route, which you will find threaded through the immigration system. What this means is that the Home Office have essentially outsourced their decision making to one of 4 endorsement bodies, and your first step would be to put together a robust, comprehensive plan and to put that to the endorsement body that you had selected, and they will make the decision as to whether your proposal is to be endorsed. Once you've received an endorsement, the visa application itself is a breeze. That's just a rubber stamping exercise. So innovator founders are granted a visa for 3 years. Many may then benefit from an accelerated route to settlement, so may be able to secure indefinite leave to remain after that 3-year period. But if not, it is possible to then extend in the UK. Moving on then to think about the next visa route on the slide. So this is UK expansion worker, and rather than being an entrepreneur route, this is much more structured around a business which is already established overseas, but which is looking to expand and has identified the UK market as being suitable for its expansion plans. Now, importantly, under UK expansion, the business should not already be established in the UK. So you should not have an established trading presence in the UK prior to securing this visa. There's another route we'll come on to which would apply in that circumstance. So under UK expansion, you've identified, okay, the UK market looks like the next best place for us. We want to send a team potentially of senior executives to the UK. We can send up to 5 people. They have to be senior or specialist, and they can all be sent to the UK for the purposes of establishing the UK entity. And as with the other 2 routes that we'll look at, this is a licensing rather than an endorsement process. So the overseas business would apply for a license as a expansion worker business. That license would be granted. The proposed team, or can be one person if that's what's required, would then be sponsored under that license. That would enable them to secure their visa clearance, and then they would be able to move to the UK to establish the UK entity. Now, importantly, it just gives you a window. So it just gives you a window for the establishment of the business in the UK, and that initial period or window is 12 months. So you secure visa clearance for 12 months. You can extend it for another 12 months, but 2 years is the maximum time period that can be spent on this visa. However, the usual model is that you secure the initial license, send the team over, establish the business, and then add tiers to the license. And those tiers may be one or both of the other 2 routes on my slide there. So they could be senior specialist worker, which is a global business mobility tier, and it could be skilled worker. And your existing expansion worker visa holders, so your senior team who've come in, set up the business, could then switch their visa into one of these other 2 visa types. And the reason that they would do that would be to enable them to stay in the UK longer, to continue to run the business and to be employed by the UK business. Now, senior specialist worker can be used for an existing trading business in the UK. This is typically where it's used typically where we have a UK entity and an overseas entity linked within the same group, and we're wanting to transfer, as it says, senior or specialist workers from overseas into the UK to enable them to be able to work for the UK entity. There is a minimum, as with all these things, the minimum salary threshold under senior or specialist worker, that's 48,500. And in most cases, a senior or specialist worker would have needed to be employed by the overseas business for a period of at least 12 months, unless they're switching, as we've talked about, potentially from expansion worker and they're turning into a senior or specialist worker. Now, this is a longer-term business, a longer-term visa route in that it can be granted for up to 5 years, but it doesn't in itself lead to what we call settlement or indefinite leave to remain. But the final visa route that I'm going to look at does lead to settlement or leave to remain. So it may be that actually the trajectory of a person's transfer to the UK goes expansion worker, establish a business, maybe senior or specialist worker, or you might use that route to bring other senior specialist workers from the overseas entity. And then at some point, if they were looking to stay in the long term, they would then be switching into skilled worker. So skilled worker is easily the largest work visa route under the UK visa system. It can be used to recruit into any genuine vacancy, provided that that meets the required skill and salary level. And under current rules, this route leads to indefinite leave to remain after a period of 5 years. But in the recent white paper that was published last week, there are proposals for that to be extended to 10 years across the board. So we'll have to see what comes out in the wash with that one and what ends up happening. Now, there is a route that has become sort of more popular. It isn't technically a route which is endorsed by the Home Office, and you won't see it in any government published papers, but it's something which is known as self-sponsorship. And this is essentially where a person has a business idea, they set up their business in the UK, they secure a license, and then they use that license to sponsor their own role, so to sponsor themselves, to secure their own visa, to come into the UK, to then continue to run the company. Now, the Home Office is not keen on this route, and I think we will start to see it be tightened up in the coming months and years. However, provided the business is genuine, once you're securing the skilled worker license, is trading, and the vacancy is genuine and the other specific requirements are met, there's nothing to actually stop a person being sponsored into a role in their own business under self-sponsorship for skilled worker. So there are lots of other very niche categories in the immigration rules which could apply to a person's very particular personal circumstances. But what I've tried to do today is just to give you a really good overview of the key routes for business establishment and for employment within a business once it's established. So I hope I've managed to do that. And now I'm going to hand over for the last session today, and then we'll come on to questions. So handing over to Callum and Adrian in our tax team. Thank you.
Well, thanks, Emma. So good morning, everyone. You should now have a good idea of sort of what it takes and what considerations you should have coming into the UK. You've got your business set up here and you started trading. So now we're going to look at how that entity that you've brought into the UK would be taxed. So there are two main ways that a UK entity can be deemed UK tax resident. The first one is incorporation. So you're automatically UK resident if incorporated in the UK. And this is unless that the residency can be proved under the laws of another jurisdiction. And then the second way that UK residency can be determined is through the management and control test. So this is the highest level of management and control being exercised from the UK. And this is the actual, might be evidence rather for the actual location of board decisions or the physical locations of managers when board decisions are made, amongst other considerations, but largely the decision making will lie at the level of the board. And so these are the two main considerations to have in mind. Equally, that management and control test can apply to UK entities leaving, but obviously on this today's call, we're focusing on people coming to the UK. So the effects then of corporate residency is that one, the company itself is subject to UK corporation tax on its worldwide profit and gains. And two, there is a duty to disclose its residency or its tax affairs to Companies House and HMRC respectively. And the level of disclosure will depend on whether that that entity is registered in the UK, i.e. incorporated, or if it's been brought into the UK tax net via the Centre of Management and Control. So if we can just move on to the next slide, please, Tom. So as I mentioned, there are ways in which a non-UK entity can become UK tax resident. And this is, like I say, one through the management and control. the point of regarding management and control is that the entirety of the tax of the corporate entity becomes UK tax resident, and just a refresh there of the effect and the steps taken to attain UK tax residency. There are also permanent establishments, which Ellie touched on earlier, which are sort of a quasi company, almost a part of an overseas entity, which is subject to UK corporation tax. So a permanent establishment is a fixed place of business through which the business of an enterprise is wholly or partly carried on, and that's defined in the OECD model tax treaty. So you're likely to find this definition in other tax treaties amongst other key economic and strategic partners across the world. So a permanent establishment may include a place of management, as I mentioned. It may include a branch or an office of a business or a factory, for instance. And there's a key point on this, the meaning of fixed. So there has to be a degree of permanency for a permanent establishment to be fixed. And for most cases, this will be 6 months. However, under certain double tax treaties, this may be extended to 12 months for certain operations. So for instance, building and construction projects or installation projects, that's only permanent if it's lasting for more than 12 months. But for the most part, it's 6 unless stated otherwise. So the tax effect of a permanent establishment is that the profits attributable to the UK permanent establishment are taxed in the UK, and equally, if it was going the other way, the profits attributable to a foreign permanent establishment would be taxed in that jurisdiction also. There's a question there to be answered on how profits are attributed. So if that permanent establishment were to operate as its own entity, any profits arising from that separate operation would be deemed in this case to be profits attributable to the permanent establishment. So to give you an example, say you had a permanent establishment which was a factory which made goods, and goods were sold from that factory, the profits would be attributable to that UK permanent establishment. There is an issue then with permanent establishments, firstly for VAT purposes, where the place of supply is and whether there's a UK VAT requirement or whether this VAT requirement would be located elsewhere. And there's also a potential risk against double taxation if tax is paid in the UK establishment, but nevertheless a taxation right exists in the home jurisdiction I'll refer to, the place of incorporation of the main company. So there may be ways in which you need to be the double taxation needs to be either exempted or credited thereafter, which could create significant cash flow issues. And there's also a risk that a permanent establishment in the later operation may risk the entire tax residency of the company shifting if, say, management move overseas and start working from the office of the permanent establishment. There is a risk rather that they bring the whole tax residency with them. So if we could move on to the next slide, please, Tom. So as Ellie touched on earlier, there's a choice really of corporate vehicles in which you can establish in the UK. So I'm just going to touch on the taxation of those also. So if you wish to establish a private limited company, this is going to be considered tax opaque. So essentially the limited company is itself a taxable person and is taxed to UK, is charged to UK tax on that basis. So any worldwide income rather arising from that limited company will be taxed in the UK. There may also be a credit / exemption if, for instance, the UK company has an overseas parent which is also charged tax on the same profit arising, then there may be a way to reduce the double taxation. But there is a potential mismatch also with the treatment of limited companies. So, for instance, in the United States, a Delaware limited company is treated as tax transparent, but in the UK, a limited company is treated as tax opaque. So, if, for instance, there was or this may apply in different jurisdictions also, but for an example, if that were to apply, then there may be some cross-border tax issues / adjustment of profits arising, which need to be taken into consideration. A limited liability partnership is different. So this is a tax transparent entity when it's trading. So this means that the tax treatment follows that of its members and the profits fall on the members themselves. So a trading UK limited liability partnership with overseas members, the profits arising from that LLP will then be taxed on the overseas members themselves and not the LLP. So this is in relation to UK sources of profits arising from UK sources only. And again, the credit exemption method may apply if those UK sourced profits are taxed elsewhere also. And as I mentioned, the permanent establishment is taxed if it's established in the UK, but it's taxed as if it were a limited company essentially. So it's treated as being its own opaque entity. So tax opaque structures may be useful, for instance, where the profits themselves arise in the UK and only arise in the UK. So you can sort of ring fence UK profits to UK tax. But if you, for instance, had UK operations, but the source of the profits are arising elsewhere, for instance, I'm thinking fund management particularly, then a tax transparent entity such as an LLP may be more useful. If we could just move on to the next slide, please, Tom. Thank you. So, as I mentioned, there are potential circumstances in which an entity may be dual resident or taxed in two different jurisdictions. So, like I say, the risks of the dual residency are the double taxation and the cash flow issue. If it can't be exempted and it has to be credited, the credit can take a while to return, which may significantly impact on cash flow. Or if neither apply, then double taxation can be disastrous for businesses. There are also trading requirements for certain reliefs. So if you're resident in the UK and elsewhere, for instance, if there was a loss relief, which we'll touch on later, which applies to profits arising in two different jurisdictions, then there's a trading requirement. So if you're dual resident and you had a non-trading entity, for instance, you may not be able to rely on certain reliefs that apply to that entity. And then there's also some administrative and reporting requirements, as I mentioned previously. If you become UK tax resident as well as tax resident elsewhere, there may be dual reporting requirements, which may increase costs and time spent on them also. It's also important to note that for dual residency, even if an entity is not dual resident, rather, there's some taxes and rules related to those taxes apply regardless. So transactional taxes, for instance, stamp duty on land and stamp duty on securities, as well as taxes arising from the owning and management of UK land from an overseas entity. These will apply regardless if the overseas entity is UK incorporated. Luckily, to help reduce the risk of dual tax residency, there are tiebreaker clauses in the relevant double tax treaty. Basically, where there's a permanent home for individuals, if there's a permanent home established, for companies, if there's a centre of vital interest, which is located in one rather than the other jurisdiction, then the tax residency can essentially be severed, and the company or individual will be treated as being tax resident only in one jurisdiction. And also within the double tax treaties, as I mentioned before, there are provisions for the elimination of double taxation itself. So these are usually the exemption method, which outright blocks double taxation, or the credit method, which allows a credit to be applied on the taxation in one jurisdiction against tax paid in another. And if we could just move on to the final two slides, I'm going to touch on these very briefly because I'm aware we're short on time and I want to get to some questions we might have. So for those entities which have cross-border structures or cross-border operations, there are certain specific taxes which might apply and might be aware of, which those single jurisdiction entities might not have to worry about. So, for instance, the diverted profits tax, if there are agreements in place to transfer profits to an entity with no economic substance, or there's arrangements in place which avoid creating a UK permanent establishment, which if it were established would obviously create a UK taxation problem. The UK rules apply to sort of see through these schemes or arrangements to the point where those profits that were diverted fall back into the UK tax net. But this only applies post 2015, so it's going to be relevant now going forward, but less so in historic contexts, which was why it might have seen certain structures fall out of favour recently. There's also transfer pricing and thin capitalisation rules, which apply particularly to those with cross-border transactional work. So transfer pricing essentially applies a market value rule to the price of services or goods transferred between two connected companies, which might create a taxation issue. For instance, if profits are deemed to have arisen, which didn't actually arise, there may be a dry tax charge on the receiving company on its profits. And the thin capitalisation rules apply a fixed ratio limit on interest, which are deductible for tax purposes. And this is to essentially avoid companies having a high ratio of debt to equity funding, which is highly favoured toward debt. So the companies can't essentially charge an obscene amount of interest on their subsidiary and deduct that interest for tax purposes. There's also withholding tax on interest as well. So if a UK source interest or UK source royalties arise in the UK, then HMRC require a 20% amount of that to be withheld and paid to HMRC. There are exemptions for certain recipients. For instance, individuals or banks aren't subject to this withholding tax. There's also ways to mitigate it as well. So that can then later be credited. The amount withheld can later be credited in the home jurisdiction, or there's also a reduced percentage under some DTTs, double tax treaties, which can be applied to HMRC for and receive essentially acceptance to withhold at that rate. There's also loss relief as well, which has changed recently to fall. So the EU loss relief rules used to be more favourable. They now fall in line more generally with the worldwide loss relief. So losses can only be deducted if they can't be deducted elsewhere. So there is no longer any double deduction of losses for EU or EEA companies. And then finally, Tom, if we can just move on to the last slide. There are some sector-specific taxes to be aware of. So if you just click through all of these, and I'll bring them up as they go. So environmental taxes, for instance, the climate change levy for more industrial businesses, stamp taxes and envelope, the annual tax on envelope dwellings or ATED. These apply to more to businesses in land, dealing with land rather. But stamp taxes also on the dealing in UK securities. There's customs and excise duty and the soft drinks industry levy for food and beverages companies, which to be aware of. There's a digital services tax, which is essentially a tax on digital services, which may apply also. The construction industry scheme, which is essentially a withholding regime on construction services and construction operations done in the UK to certain businesses. And then there's also business rates to be applied if you open a branch or an office, for instance, or a shop or factory in the UK to be aware of. And also something which isn't mentioned on there, obviously, is employer taxes, employer NICs, and requirements to account for employee NICs and employee income tax. Which has been mentioned, but obviously businesses coming to the UK and operating a business here should nonetheless be aware of. So that brings us to the end of our third seminar. I'm going to pass over to Adrian now to run through some of the questions we've had that come through on the chat box.
Yeah, thanks, Callum. I think we may be a bit short of time, but there was one in the Q&A here, probably for Roger, around insurances. Is there any difference between the business insurances that are compulsory for the companies to have under specific structures? And is there any compulsory and optional list depending on the setup and insurance level? So I think it's the question is around whether or not there are different insurances for companies, partnerships, etc., the way in which a business is established. Although I think more generally that the UK does require lots of insurances, but I'm not sure if that's something that.
Well, so yeah, not as many as you might think actually. I think it's employers' liability. If you're employing employees, you need employers' liability insurance, and you'll also need to have motor insurance. But as far as I'm aware, those are the only two mandatory ones, and that applies across all businesses, whatever their structure.
Okay, then we have just a minute left, and this is perhaps one for Callum. One of them is around. Let me see if we can get this one in. So a business has sent an employee to the UK as a sales agent. Doesn't state whether or not the sales necessarily need to be, whether that person can endorse the sales or whether or not they need to be ratified back in the home country. But he's in the UK permanently, so presumably UK tax resident with only occasional trips home. Does he have to register a permanent establishment in the UK? Should he pay UK income tax under PAYE? Can he claim a credit against that tax in his home country? So quite a lot there, but I think it's probably largely around the permanent establishment point.
Yeah, I think you touched on there, Adrian, as well. It's the level to which he can bind that company to that sale. So if he, for instance, has authority to go out and essentially do as he pleases on behalf of the company to bind the company to a particular contract, then yes, there's likely a permanent establishment risk there. There's also a question to ask him where he's working, if he's working from home or if he's working from an office or branch. Obviously, the level of which he binds the company might be lessened if he's in a branch or an office rather than if he's operating on his own behalf. Regarding the income tax on himself personally, there would be rules under the DTT, I'd assume, and also under some social security or reciprocal agreements, which would need to be looked at. But I think that's sort of separate to the business itself and the tax that would apply on him. And then, yeah, again, in terms of credit, that would be supplied for in the double tax treaty if necessary, and would have to be looked at jurisdiction by jurisdiction. But yes, there would be. There would likely be a credit method against tax already paid in the home country.
Okay, I think we've probably run out of time, so I'll hand back to Tom.
Thanks very much for everyone that attended. As Emma said at the start, we'll be sharing the recording and the slides with everyone. Thanks very much. Have a good day.